It's always a pleasure to welcome you back to our channel. Today we will dive into 10 key areas of DIY legal mastery, teaching you to effectively tackle these tasks without breaking the bank on attorney fees. Key points covered in this video. 1. Drafting a simple will. Drafting a simple will is an essential part of estate planning, ensuring that your assets are distributed according to your wishes after your passing. A will delineates the distribution of your estate, including assets and possessions, among selected recipients like loved ones or charities. When drafting a simple will, consider the following steps. Identify your assets. Make a list of all your assets, including real estate, bank accounts, investments, retirement accounts, vehicles, personal belongings, and any other items of value. Choose beneficiaries. Decide who will receive your assets and in what proportions. You can name multiple beneficiaries and specify the percentage of your estate each one will inherit. Appoint an executor. Select a trusted individual to serve as the executor of your estate. The executor will be responsible for carrying out the instructions in your will, including paying off any outstanding debts and distributing assets to the beneficiaries. Designate guardians for minor children. If you have minor children, it's essential to name a guardian who will be responsible for their care and upbringing in the event of your death. Specify funeral and burial arrangements. You may wish to include instructions regarding your preferred funeral and burial arrangements, such as the type of service, burial location, or any specific preferences you have. Sign and date the will. To make your will legally valid, sign and date it in the presence of at least 2 witnesses who are not beneficiaries in the will. The witnesses must also sign the document to confirm that they saw you sign it. Store the will safely. Keep the original will in a safe and secure location, such as a fireproof safe or a safety deposit box. Inform your executor and trusted family members of the location. It's important to review your will periodically and update it as necessary to reflect any changes in your life, such as marriage, divorce, the birth of a child, or the acquisition of new assets. Although drafting a simple will may be sufficient for some individuals, it's always a good idea to consult with an attorney or estate planning expert to ensure that your will accurately reflects your wishes and complies with your state's laws. 2. Creating a power of attorney. Creating a power of attorney, POA, is a crucial step in planning for the possibility that you may become unable to make decisions for yourself due to illness, injury, or other circumstances. A POA is a legal document that designates a trusted individual, called an agent or attorney in fact, to make decisions on your behalf when you are unable to do so. This person can manage your financial affairs, make medical decisions, or handle other personal matters, depending on the scope of authority you grant them. Here are the key steps in creating a power of attorney. Choose your agent. Select someone you trust, such as a spouse, adult child, close friend, or family member. This person should be reliable, responsible, and capable of handling the tasks you assign to them. Determine the type of POA. There are different types of powers of attorney, such as a general POA, which grants broad authority to manage your affairs, or a limited or special POA, which grants specific powers for a particular purpose, such as selling a property. A durable POA remains in effect even if you become incapacitated, while a non-durable POA becomes invalid in such circumstances. A springing POA, which becomes active only under certain circumstances such as a medical professional determining incapacity, is another option. Specify the scope of authority. Clearly outline the powers and responsibilities you want to grant your agent. These may include managing finances, making medical decisions, handling legal matters, or any other responsibilities you wish to delegate. Consult an attorney. It's a good idea to consult with an attorney who specializes in estate planning or elder law to ensure your POA complies with your state's laws and accurately reflects your wishes. They can help you draft the document and provide guidance on any specific language or provisions you should include. Sign and notarize the document. To make your POA legally valid, you and your agent must sign the document in the presence of a notary public. The notary will verify your identities, witness the signing, and affix their seal to the document. Inform relevant parties. Notify your family, friends, financial institutions, and medical providers about your POA, and provide them with copies if necessary. This helps ensure that your agent's authority will be recognized when they need to act on your behalf. Review and update as needed. Regularly review your POA and update it as needed to reflect any changes in your life, such as changes in your relationship with your agent or alterations in your wishes regarding the scope of their authority. Remember, creating a power of attorney is a crucial aspect of planning for the future and ensuring that someone you trust will be able to make decisions for you when you cannot do so yourself. 3. Handling small claims court matters. Handling small claims court matters involves resolving minor disputes without the need for an attorney. Small claims courts are designed to be user-friendly and cost-effective, allowing individuals to represent themselves in cases involving relatively small amounts of money, typically ranging from a few hundred to several $1,000s, depending on the jurisdiction. Here's how to handle small claims court matters. Determine if your case qualifies. Ensure that your case falls within the jurisdictional limits of your local small claims court, which are usually based on the monetary value of the dispute. Common types of cases include unpaid debts, property damage, breach of contract, and disputes over goods or services. Try resolving the dispute informally. Before filing a claim, attempt to resolve the matter with the other party through negotiation, mediation, or other informal means. This method potentially reduces expenses and saves valuable time for everyone involved. Prepare your case. If informal resolution isn't possible, gather all relevant documents, evidence, and witnesses to support your claim. This may include contracts, receipts, photographs, emails, or other communications related to the dispute. File your claim. Complete the necessary forms and submit them to the small claims court, along with any required fees. You'll need to provide basic information about yourself, the other party, and the nature of the dispute. Serve the defendant. Notify the other party, the defendant, of the lawsuit by serving them with a copy of the filed claim and a court summons, as required by your jurisdiction. This can usually be done through certified mail or by hiring a process server. Attend the hearing. On the scheduled court date, present your case before a judge or magistrate. Be prepared to explain the facts of the dispute, present your evidence, and answer any questions the judge may have. The defendant, too, will have a moment to voice their version of events. Receive the judgment. After hearing both sides, the judge will make a decision and issue a judgment, which may be announced immediately or within a few days. If you win, the defendant may be ordered to pay you the amount claimed, plus any court costs. Enforce the judgment. If the defendant doesn't voluntarily pay the judgment, you may need to take additional steps to collect the money, such as garnishing wages, seizing bank accounts, or placing a lien on their property. Appeal, if necessary. If you believe the judge's decision was incorrect, you may have the option to appeal the judgment. Be aware that the appeal process can be more complex and may require the assistance of an attorney. By following these steps, you can navigate small claims court matters and resolve minor disputes without the need for an attorney. However, if your case is more complicated or you're unsure of the process, it may be beneficial to consult with a legal professional for guidance. 4. Negotiating contracts. Negotiating contracts is a crucial skill to protect your interests in business and personal agreements. Whether you're entering a partnership, signing a lease, or hiring a service provider, effective negotiation ensures that your needs are met and potential risks are minimized. Here's how to approach contract negotiation. Preparation. Before entering negotiations, research the subject matter and the other party involved. Understand the market norms, legal requirements, and any potential risks. Identify your objectives, priorities, and potential areas of compromise. Know your BATNA, best alternative to a negotiated agreement. Determine your fallback plan in case negotiations fail, and know when walking away from the deal might be the better option. Understanding your BATNA gives you more leverage and confidence during negotiations. Build rapport and trust. Establishing a positive relationship with the other party can help facilitate negotiations. Be respectful, open, and professional in your communications, and listen carefully to their concerns. Focus on interests, not positions. Instead of taking a rigid stance, identify the underlying interests of both parties. This can help you find creative solutions and foster a collaborative approach. Be clear and specific. Clearly articulate your terms, expectations, and any conditions. Lack of clarity can foster eventual miscommunications and quarrels down the line. Prioritize and compromise. Recognize that you may not get everything you want. Identify your most important terms and be prepared to make concessions on less critical items. Don't rush the process. Successful negotiation takes time and patience. Avoid making hasty decisions or accepting unfavorable terms just to close the deal quickly. Use objective criteria. Support your proposals with objective data, such as industry standards, market rates, or legal requirements. This can help legitimize your position and facilitate agreement. Verify and document. Once you've reached an agreement, ensure that all terms are accurately documented in the contract. Both parties should review and sign the document to formalize the agreement. Seek legal advice when necessary. If you're dealing with a complex or high-stakes contract, consult with an attorney to ensure that your interests are adequately protected and the contract complies with applicable laws. By developing effective negotiation skills and following these steps, you can protect your interests and create mutually beneficial agreements in both business and personal situations. 5. Understanding landlord-tenant law. Understanding landlord-tenant law is essential for both renters and property owners to ensure a smooth rental relationship and avoid potential disputes. While specific regulations may vary by jurisdiction, there are some general principles and rights that apply in most cases. Here's an overview of key aspects of landlord-tenant law. Lease agreements. A lease acts as a legally sanctioned contract between the property holder and renter, outlining the rental's terms and conditions, including rent price, due dates, agreement duration, and property restrictions. A clear understanding of the lease by both parties is essential before putting pen to paper. Security deposits. Landlords typically require a security deposit from tenants to cover potential damages or unpaid rent. Laws may regulate the maximum amount, how the deposit is held, and the timeline for returning it after the lease ends. Right to habitable premises. Landlords must provide and maintain a safe, clean, and habitable living environment. This includes ensuring that the property has adequate heating, plumbing, and electrical systems, and is free from hazards, pests, and structural defects. Maintenance and repairs. Landlords are generally responsible for maintaining the property and making necessary repairs, while tenants are responsible for keeping the premises clean and reporting any problems. In some cases, the lease may specify certain maintenance responsibilities for the tenant. Right to privacy. Tenants have a right to privacy in their rental unit, and landlords must provide reasonable notice before entering the premises for inspections, repairs, or other legitimate reasons, unless there's an emergency. Rent increases and eviction. Laws may govern how and when landlords can increase rent, as well as the process for evicting tenants. Generally, landlords must provide written notice of rent increases or eviction, and tenants have the right to contest an eviction in court if they believe it's unjustified. Discrimination. Rental regulations typically disapprove of discriminatory behavior based on elements like race, religious creed, sex, incapacities, familial situation, or nationality. Renters' rights. Tenants have various rights, including the right to withhold rent under certain circumstances, the right to form or join a tenants' union, and the right to report code violations to local authorities without fear of retaliation. Landlords' rights. Landlords also have rights, such as the right to collect rent, enforce the terms of the lease, and if necessary, evict tenants who breach the lease or fail to pay rent. Dispute resolution. In case of a dispute between landlords and tenants, there are various options for resolution, such as negotiation, mediation, or litigation. Local tenant advocacy organizations and legal aid services can provide guidance and assistance. Understanding landlord-tenant law is crucial for both renters and property owners to ensure a successful rental relationship and avoid potential disputes. It's important to familiarize yourself with the specific regulations in your jurisdiction, as laws may vary. 6. Filing for a trademark or copyright. Filing for a trademark or copyright is an essential step to protect your intellectual property, IP, without a lawyer's assistance. Trademarks protect brand names, logos, and slogans, while copyrights protect original works of authorship, such as books, music, and artwork. Here's an overview of how to file for a trademark or copyright on your own. Trademark. Conduct a search. Before filing, perform a search on the United States Patent and Trademark Office, USPTO database, to ensure that your desired trademark isn't already registered or pending registration by another party. Ascertain the suitable category. Trademarks are organized into distinct classes, reflecting the goods or services they encompass. Pinpoint the classes relevant to your trademark. Prepare the application. Gather the necessary information, including the trademark's name or design, a description of the goods, services it represents, and a specimen showing the trademark's use in commerce. File the application. Submit your trademark application online via the USPTO's Trademark Electronic Application System, TEAS. Pay the required filing fee, which varies depending on the application type and the number of classes you're registering for. Monitor and respond to office actions. After filing, the USPTO will review your application and may issue office actions requesting additional information or clarification. Respond promptly to avoid delays or potential abandonment of your application. Approval and registration. Once approved, your trademark will be published in the official Gazette for opposition. If no oppositions are filed within 30 days, your trademark will be registered, and you'll receive a certificate of registration. Copyright. Determine eligibility. Ensure that your work is eligible for copyright protection. The work must be original and creative, captured in a solid form of expression. Prepare the application. Gather the necessary information, such as the title of the work, the author's name, and the date of publication, if applicable. File the application. Submit your copyright application online using the U.S. Copyright Office's Electronic Copyright Office, ECO system. Alternatively, you can file using paper forms, though this may be slower and more expensive. Submit deposit materials. Along with your application, submit a copy of the work being copyrighted. For online applications, you can usually upload a digital copy of the work. For paper applications, you'll need to mail a physical copy to the Copyright Office. Pay the filing fee. Pay the required filing fee, which varies depending on the type of application and the method of submission, online or paper. Receive your registration. The Copyright Office will review your application, and if approved, issue a certificate of registration as proof of your copyright ownership. By following these steps, you can file for a trademark or copyright without a lawyer's assistance, effectively protecting your intellectual property rights. However, if you encounter complexities or need legal advice, consulting an attorney specializing in IP law may be helpful. 7. Navigating family law matters. Dealing with family law situations demands coping with emotional strain and legal challenges. Family law extends over an extensive range of subjects, including divorce proceedings, child custody battles, child support negotiations, alimony arrangements, and more. While it's often best to consult with an attorney in these situations, gaining insight into some key aspects of family law can help you better understand the process and make informed decisions. Here's an overview of some common family law matters. Divorce, the lawful dissolution of a marital union. Each state has its own divorce laws, but most follow either a fault or no-fault approach. In a no-fault divorce, neither spouse needs to prove the other's wrongdoing, and the marriage can be dissolved due to irreconcilable differences. In a fault divorce, one spouse must demonstrate that the other's actions, such as adultery or abandonment, led to the breakdown of the marriage. Division of assets. During a divorce, marital assets and debts must be divided between the spouses. Depending on the jurisdiction, this may be done according to community property or equitable distribution principles. In states with community property laws, assets accrued during the union are usually divided 50-50. In equitable distribution states, assets are divided based on what the court considers fair and equitable, considering various factors such as the length of the marriage and each spouse's financial contributions. Alimony, often known as spousal support, it signifies the financial assistance one spouse extends to the other amid or after a divorce. Alimony aims to mitigate the unequal financial consequences of a divorce by offering continuous monetary assistance to the lesser-earning spouse. Factors such as the length of the marriage, each spouse's earning capacity, and the standard of living during the marriage may be considered in determining alimony. Child custody. In a divorce or separation involving children, decisions must be made regarding child custody, which includes both legal custody, decision-making authority, and physical custody, where the child resides. Custody arrangements can be determined through negotiation, mediation, or if necessary, by a court. The best interests of the child are always the primary consideration in custody decisions. Child support. Both parents bear a legal duty to provide financial assistance to their offspring. Child support is a payment made by the non-custodial parent to the custodial parent to help cover the costs of raising the child. Child support calculations generally take into account the income of both parents, the number of children, and the custody arrangement. Paternity. Establishing paternity is the legal process of determining a child's biological father, which can be important for child support, custody, and inheritance rights. Paternity can be voluntarily acknowledged by the father or established through a court-ordered DNA test. Adoption. Adoption is the legal process by which an individual or couple becomes the legal parent of a child who is not biologically their own. Adoption laws vary by state and can involve complex procedures, including background checks, home studies, and court hearings. Domestic violence. Family law also addresses issues of domestic violence, which can involve obtaining protective orders, restraining orders, and addressing related child custody and support issues. Navigating family law matters can be challenging, and each situation is unique. While gaining insight into these topics is helpful, it's often best to consult with an experienced family law attorney who can provide personalized guidance and representation tailored to your specific circumstances. 8. Dealing with debt collecting. Dealing with debt collection can be a stressful experience, but understanding your rights and knowing how to handle creditors and collection agencies legally can help you navigate the process more effectively. Here's an overview of some key aspects to consider when dealing with debt collection. Know your rights. Familiarize yourself with the Fair Debt Collection Practices Act, FDCPA, which protects consumers from abusive, deceptive, or unfair debt collection practices. This federal law sets guidelines for how and when debt collectors can contact you, and it prohibits certain behaviors, such as harassment, threats, or misrepresentations. Verify the debt. When contacted by a debt collector, request written validation of the debt, including the amount, the name of the original creditor, and proof that the collector has the legal right to collect the debt. Debt collectors are required to provide this information under the FDCPA. Keep records. Maintain detailed records of all communication with debt collectors, including dates, times, and the names of the individuals you speak with. Keep copies of any written correspondence, as well as any payment receipts or agreements. Set communication boundaries. Under the FDCPA, you have the right to specify how and when debt collectors can contact you. You can request that they stop contacting you at work, or that they only communicate with you in writing. If you wish to stop all communication, you can send a cease and desist letter. But be aware that this may prompt the collector to initiate legal action. Negotiate a repayment plan. If you're unable to pay the debt in full, consider negotiating a repayment plan or debt settlement with the collector. Be realistic about what you can afford, and try to reach an agreement that satisfies both parties. Make sure to get any agreement in writing. Avoid admitting liability. Be cautious about what you say during communication with debt collectors, as your words can potentially be used against you. Avoid admitting liability for the debt, making promises to pay, or providing personal information that could be used to collect the debt. Dispute inaccurate information. If you believe that the debt is incorrect or fraudulent, dispute the information with the credit reporting agencies and the original creditor. Provide any supporting documentation, such as payment records or identity theft reports. Understand the statute of limitations. Debts have a statute of limitations, which varies by state and the type of debt. After this time period has elapsed, creditors generally cannot sue you to collect the debt. However, be aware that making a payment or acknowledging the debt can restart the statute of limitations. Pursue legal counsel. If confronted with a lawsuit or suspecting a debt collector has infringed upon your rights, seek advice from a lawyer adept in consumer protection or debt collection defense. They'll clarify your choices and recommend the optimal strategy. By understanding your rights and knowing how to handle debt collection legally, you can better manage your financial situation and minimize the stress associated with dealing with creditors and collection agencies. 9. Responding to traffic violations. Responding to traffic violations can be frustrating and confusing, but understanding your options when faced with a ticket or fine can help you make informed decisions. Here's an overview of some key aspects to consider when dealing with traffic violations. Review the citation. Carefully read the traffic ticket to understand the nature of the violation, the applicable fine, and any additional penalties, such as points on your driving record. Ensure that the information on the ticket is accurate, including your personal information, vehicle information, and the details of the violation. Decide on your course of action. Once you've reviewed the citation, you need to decide whether to pay the fine, contest the ticket, or attend traffic school, if eligible. Consider factors such as the strength of your defense, the potential consequences of a guilty verdict, and the time and expense involved in contesting the ticket. Pay the fine. If you decide to pay the fine, follow the instructions on the ticket to make the payment by the specified deadline. Keep in mind that paying the fine is an admission of guilt and may result in points on your driving record, which may adjust your insurance expenses and possibly lead to license suspension if you rack up too many points. Contest the ticket. If you believe the ticket was issued in error or you have a valid defense, you can choose to contest the ticket. This typically involves attending a court hearing, where you'll have the opportunity to present evidence and argue your case before a judge. Be prepared to present any supporting documentation, such as photographs, witness statements, or maintenance records. Request a trial by written declaration. In some jurisdictions, you may have the option to contest your ticket through a written declaration. This involves submitting a written statement, along with any supporting evidence, explaining why you believe the ticket should be dismissed. The officer who issued the ticket will also submit a written statement, and the judge will make a decision based on the written submissions. Consider traffic school. If you're eligible, attending traffic school may be an option to avoid points on your driving record and potentially reduce your insurance rates. Traffic school courses typically cover safe driving practices and traffic laws and may be offered in person or online. Completion of the course usually results in the dismissal of the ticket or a reduction in points assessed. Hire an attorney. If you're contesting a ticket for a serious traffic violation or you believe you have a strong case, you may want to consider hiring an attorney who specializes in traffic law. An experienced attorney can help you navigate the legal process, present your defense effectively, and potentially negotiate a reduced penalty or dismissal. Understand the consequences. Be aware of the potential consequences of a traffic violation, such as points on your driving record, increased insurance rates, license suspension or revocation, and possible criminal charges for more serious offenses. By understanding your options when faced with a traffic violation, you can make informed decisions and effectively manage the situation. Remember that every jurisdiction has its own traffic laws and procedures, so it's important to familiarize yourself with the specific regulations in your area. 10. Preparing for a legal consultation. Preparing for a legal consultation is essential to ensure that you maximize your time with an attorney, get the most out of the meeting, and lay the groundwork for a successful attorney-client relationship. Knowing what to expect and what questions to ask can help you make the most of your consultation. For a brief rundown on how to prepare, gather relevant documentation. Collect all relevant documents and information related to your legal issue, such as contracts, emails, correspondence, photographs, receipts, medical records, or any other evidence that may be pertinent to your case. Organize these materials in a logical manner to make it easy for the attorney to review them. Write a concise summary. Prepare a brief, clear, and concise summary of your legal issue, including a timeline of events, names of parties involved, and key facts. This summary will help you communicate the essential details of your situation to the attorney and provide a useful reference during your consultation. Research the attorney. Before your consultation, research the attorney's background, experience, and areas of expertise. Familiarize yourself with their practice areas and ensure that they have experience handling cases similar to yours. This can help you have confidence in their ability to handle your case effectively. Prepare a list of questions. To get the most out of your consultation, prepare a list of questions in advance. You could ask, how proficient are you in dealing with cases similar to mine? What is your assessment of my case? What are my legal options and potential outcomes? What could be the likely duration before my case is resolved? Will you be personally handling my case, or will other attorneys or staff be involved? What fees are associated with your services, and how is billing conducted? Can you provide references from previous clients with similar cases? Be prepared to take notes. Bring a notepad and pen to your consultation to take notes on the attorney's answers, advice, and any additional questions that arise during the meeting. Be honest and open. During your consultation, it's crucial to be completely honest and open with the attorney about your situation, even if some details may be uncomfortable or unflattering. This will allow the attorney to provide the most accurate advice and help them understand the full scope of your legal issue. Discuss next steps. Before concluding your consultation, ask the attorney about the next steps in the process, any actions you should take immediately, and how you can maintain communication with them moving forward. By preparing thoroughly for your legal consultation, you can make the most of your time with the attorney, ensure that they have all the necessary information to advise you effectively, and begin building a strong foundation for your attorney-client relationship. Engage with us and join our community. Congratulations on making it this far in our journey to break down daunting laws and master practical legal tips. We hope you found the information valuable and feel more confident in your ability to navigate the world of law. We'd love to hear from you and continue to support your legal education journey. Engage with us by leaving comments, asking questions, and sharing your own legal experiences. Your feedback and insights will help us create even more valuable content for our community. Don't forget to follow us on social media to stay updated on the latest legal tips, news, and insights. Instagram handle, @LegalEaglyCathabrief, Twitter handle, @LegalEaglyKB. Connect with other aspiring law students, paralegals, and self-learners in our community, and continue learning from one another. Finally, if you haven't already, be sure to subscribe to our YouTube channel for more practical legal tips and resources. Together, we can continue to demystify the law and empower ourselves with knowledge. Until then, keep learning and growing.